welcome to Jayanandini Tele Bangla channel. Your favorite channel, of course, where you get to meet a lot of people from different professions, different backgrounds, and you get to learn about their life story, about their journey in life, about their profession. So in that continuation, today we have invited a very distinguished gentleman, a very distinguished guest who is involved in many different sectors, business, writing, and legal practice. So let me introduce Muhammad Shahjahan Siddique, who is also known as MS Siddique, who is a legal economist by practice. He is a regular columnist and at some local daily newspapers and periodicals. He is a former non-government advisor at Bangladesh Competition Commission, Government of Bangladesh. Mr. Siddique was a part-time faculty at Daffodil International University and a trainer at different professional training institutions and trade associations. He has several books to his credit. For example, Default Loan Culture, Regulatory Reforms, Bangladesh Perspective, Financial Sector Reform, Reform for Economic Development, Legal and Illegal Corruption, Ease of Doing Business, Ease of Economic Development, Corruption, Shell Company, and Beneficial Owner. Mr. Siddique is CEO of Bangladesh Chemical and International Trading, which is an international trading company dealing with chemical and chemical technology. So we'll go to Mr. Siddique to first, when I was reading this, my attention has been drawn to the term legal economist by practice. Mr. Siddique, welcome to Jayanandini, and we will get to know about a lot of things from you. But first, let us know a little bit on what did you mean by legal economy, if we say.
It's a unknown subject or profession in Bangladesh, but in Europe there are some professionals, namely mostly the legal economists, mostly they are consultant.
Yes.
I am also doing some consultancy, of course, free of cost, not for earning money. In fact, so I was non-government advisor to the Bangladesh Competition Commission. That is also part of my profession, actually.
Okay.
Although that is also an honorary position.
Mm-hmm.
The legal economist means I am analyzing or handling this economy in the eye of law, or law in the eye of economist.
Mm-hmm.
So that means when you evaluate the economy, legal point of view, because there are quite a lots of law related to economy.
Okay.
At the same time, you will have to evaluate the law in the eye of economic activities or economist point of view. That's why this is a very unknown in Bangladesh, but a profession named legal economist.
It's more common in Europe and Western world.
There are some university, they have also some courses also on,
I see.
in this subject.
Very
and there are
interesting.
some master's degree courses.
They offer
some courses in some universities.
So the clients who come to you for consultancy, what kind of problems they face when they come to you?
In fact, say for example, the loan defaulters, rin khelapi culture. So the people, those who are indicted in under Orthorin Adalat, or they used to consult me, or sometime loan application processing. That is also, until and unless you know the law, it's very difficult. And irony of the legal part of the business is that, say for example, international trade, there is no law to regulate the international law or international transaction. It's very funny. At this, because Because Canada have their own law, Bangladesh has their own law, USA has their own law. So which law will be applicable to any dispute? So that's why there are quite a lot of convention, UN convention, and there are some protocol and convention declared by International Chamber of Commerce. Those used to regulate the international law. So, for example, the letter of credit for sending money. The format of letter of credit is drafted by International Chamber of Commerce. UCB 600 now, the latest version. So that's why if you look into the law, you will see that they used to write this letter of credit. So it is as per UCB 600.
Oh, I see.
Then the rule written in UCB 600 will be applicable in case of any dispute. So if I explain it further, I don't know how, maybe I don't know, the audience will be bored.
No.
It's a legal issue.
Yes.
Say, for example, international trade, how it happened. A company in Canada used to, or a company in Bangladesh used to buy garments from Bangladesh. So the Canadian company will go to bank, they will request them to open a letter of credit. Then this bank, Canadian bank, will open a letter of credit on a bank in Bangladesh. It's a promissory note. That promissory note stating that if so-and-so garments company deliver certain quantity of garments, shirts, to the shipping company, then you pay immediately. That means the Bangladeshi bank will pay to the garments exporter immediately after stopping the material in the container and hand over the container to the shipping company. Although it will not reach, it will reach Canada, Canadian buyer, maybe after 1 month. So they look into the document and make the payment. Then he will claim the money to Canadian bank that they have fulfilled the contractual obligation. I paid them. Now you pay to me. Then Canadian bank will pay to Bangladesh bank, Bangladeshi commercial bank. Then the Canadian bank will ask his client that your material has been shipped. So you pay your money. So now you can see how many contracts. There are more contracts. Then there is a contract between shipping company and the exporters. Shipping company will carry this material to Canadian port. Then another company, another contract between clearing agent and the importer.
There is another term, is bill of lading.
Bill of lading. Yes, exactly. Thank you very much. Bill of lading means it's a receipt of consignments. When the shipping company received the material, garments, then they used to issue a bill of lading. That means I have received so-and-so material from this company. That is the evidence that material has been shipped out.
Exactly.
Or material at the custody of shipping company. Now you see how many contracts, how many communications. You see there is no direct agreement. In this process, you can see that there is no direct contract between importer and the exporters. But there is a contract. The primary contract between importer and exporter, they will have a contract for manufacturing and supplying the material. On the basis of that contract, that is the pro forma invoice or indent, we used to call them. On the basis of this pro forma invoice, then the importer used to establish the letter of credit.
On the basis of that.
So each and every step, there is a law, there is a convention, there is a protocol. Those are binding convention. All UN convention are binding. Or say UCB 600, I say the format of letter of credit. That became binding when they put this condition within the letter of credit that this UCB 600 will apply for transaction of this deal. So I don't know, maybe it seems very complicated to the audience.
No,
but it's reality that
I'm sure
without law,
you
you cannot think of any international or even domestic transaction.
Of course. There has to be some binding factors, law and bylaws, all these come into this. This is because trading is a very complicated thing. There's lots of money involved. So, in case there is a dispute in Bangladesh, then where do you go to settle it? Which court?
I was expecting this question from you. Actually, global practice is settlement through mediation and arbitration. Because, as you know, if somebody go to the court, it will take 20 years time in our country. So they cannot wait for 20 years time.
Exactly.
They want to settle within 1 or 2 days. So the primary step is the mediation, negotiation, then arbitration. There is arbitration law, international arbitration law. There is each and every country have identical arbitration act. That also guided by United Nations Convention. United Nations advised the signatory of the convention that they will have a uniform law for arbitration. And this arbitration, there are some arbitration center in Bangladesh. There is an arbitration center. In each and every country there is an arbitration center. There are some regional arbitration center. In our region, Singapore is the best arbitration center. London is another best arbitration center. Hong Kong, New York, those are remarkable. They used to give landmark verdict. Even anywhere in this world, any center, if they give a verdict under Arbitration Act, that is binding on everybody, anywhere in the world. So, a judgment by the Dhaka Arbitration Court, it's not a court, center, that is binding on any of the participants in this dispute, from Canada, America, Japan, anywhere else. It is the responsibility of the government of that country to implement that judgment.
I think it's interesting. So this has to be among countries which are recognized by the UN, which are under UN.
Not only recognized, in fact, those who arbitration convention has been signed by those who signed
have signed the convention. Otherwise, it will be difficult.
So when they sign the document, that means the law is the convention is applicable on them, and they are bound to enact arbitration act according to standard draft law issued by published by this United Nations.
Nice, yeah, that's really okay. That's very enlightening, because I'm sure that our audience will like this your explanation and enjoy knowing a bit more about this. So, Mr. Siddique, let us go to a different area. You have also worked on default loan culture. Explain a little bit. What is default loan culture?
It is a popular word because our perception is that the borrowers used to take money, but they don't pay back. Interestingly, the Loan Recovery Act, this Orthor in Adalat Act, that is one of the strict law in the world, and to some extent it has violated the human rights of the borrowers, and also it is against the constitution. Against the constitution of Bangladesh. It may be a surprise news for you.
It is.
Because the law says only the bank, scheduled bank in Bangladesh can sue the borrowers. Borrower cannot sue the bank. And all the procedure are specified and curtailed. If anybody don't appear in the court, it doesn't matter. They can give the verdict. And that is binding. And there is no scrutiny. The borrower have nothing to say. It is something like military law. Say, for example, we have some funny story that if somebody violates the law order of superior, then they take him to the court martial.
For court martial. Yes.
Then the judge there will ask him, You have been ordered by your superior to do something? Yes. You did it? No, sir. Okay. Jail for 5 years. Termination from the job. You don't have option to explain why you could not perform or you could not follow the instruction of your boss. Same story here.
In case of default loan.
In case of default loan, the borrower have nothing to say. Only they will ask, the judge will ask, you took the money? Yes. You did not pay back? Yes, not yet. But no. Final, full stop.
Okay.
You go to jail. So
One
such
has
a
to be
strong law.
very careful while taking bank loans.
And such a strong law, it is unprecedented in the world. Even then, the bank unable to collect their money, recover their money. The story is different, but we don't discuss it.
Okay, what happens when an industrialist takes a loan of say 500 crore taka in Bangladesh, and then within a short time, within 7 days, his factory, there is a big fire in his factory, it's totally burned down, and the insurance doesn't cover. So what will happen in that case?
Insurance is a must. So it's a whole story. You are right that insurance company don't feel like to pay. So then in that case you will have to ensure that insurance company is performing their responsibility. Bankers are performing their responsibility. Otherwise, then all liability goes to the borrowers. Because of fire, because of flood, or any other reason. If the company factory shut down, no production, bank will not excuse them. That's another loophole in our law.
There is a term called force majeure.
Force majeure.
What is
not applicable? Force majeure. Force majeure is a term to excuse to fulfilling the obligation, contractual obligation. If one company, one garments industry has been given an order by a Canadian company, but if there is a war in Bangladesh, if there is a flood, storm, the factory totally destroyed, so he cannot produce the garments. Then force majeure clause will apply. That means the reason beyond control of the party concerned.
Okay, yes.
Natural calamity. There is no control over the natural calamity. That's why the failure in that case is excusable.
Well, thank you, Mr. Siddique. Tell us, they leave the country, flee and go to some foreign country with millions and millions of dollars, and then they remain untraceable. What law can really go, international law can really go and find them out, or and bring them back to the country?
Okay, first of all, if I ask you, you want to bring back money taken away by businessmen or any other person?
Any other person. Okay, right.
Because when we talk about this issue, we used to blame the businessman only.
Always, yeah.
So, okay, anybody, if they take money out of the country, according to foreign exchange law, no citizen can take away money from Bangladesh. It's restricted. Foreign currency transaction is restricted until and unless any transaction approved by Bangladesh Bank. Again, Bangladesh is a most vulnerable country in the world. It's very easy to take money from Bangladesh to other country because of the legal loopholes. And another option is our economy is mostly an informal economy. So from an informal money going to another informal economy to another country, it's very easy. But when the money is formal, economy is formal, then it's very difficult. Now, what is the law? There are many conventions again and protocol. Bangladesh is not willing to sign all this protocol.
Oh, I see.
Say, for example, there are some conventions even OECD countries. They will exchange information among the signatories. All these transactions, illicit transactions. Bangladesh is not willing to that convention. Can you recall the one story, a funny story? 5 or 6 years back, the finance minister used to revoke the Swiss ambassador in Bangladesh. We asked you to give the list of the people who deposited money in Swiss bank, but you did not give. Your government did not give. The funniest part of this story is that there is a law in Switzerland that there no banker, nobody have any right to disclose the name of the depositors. Now, what is the remedy? That's why Switzerland is the safe haven for the black money. Bangladeshi people used to deposit there.
They're still going.
And the bribe used to transact there in Switzerland for big deals. So, say German company is supplying the material to Bangladesh, they give some kickback money. So they send this money directly to Switzerland account of the politician or the brokers as bribe.
But nobody is going to ask any question.
Now, if Bangladesh signed the protocol of OECD, Switzerland is part of the OECD.
OECD.
This rich, 20 rich country of the world.
I see.
So, Bangladesh can sign that protocol, and also Bangladesh can have a mutual agreement with Switzerland for mutual exchange of information. We have such a agreement in India, we have such agreement with Singapore and many other countries. And interestingly, you know that many people has set up their purchase property in Malaysia as a second home. And Bangladesh government asked them to give the information. Malaysian government says, so, no, we shall not disclose the name. So now, the global law is, another funny law I want to tell you, since you have raised this question. There is a law in America. If any American citizen deposit any amount in any bank anywhere in the world, it is the obligation of that bank to immediately report to finance department of United States that this particular citizen having this passport number or ID number deposited certain amount of money. If you don't disclose it, then American government has right to block any of your transaction anywhere in the world and recover this money with penalty. It is a law for the Americans. Now the story is totally different. If any Bangladeshi person go there in United States and he will go to the immigration lawyer, and immigration lawyer will scrutinize this document, and he will give a statement that I have scrutinized all the documents and I find that this gentleman has brought $1 million, maybe, or $10,000 or $20,000. So he can be given green card. On the basis of certificate, they will issue a citizenship to a particular citizen. The logic they have, American government says that I did not see the documents. Why he got the money? We have given the citizenship on the basis of statement from the lawyer. Now you see, they will not allow any American company to take away any money or deposit in any account without knowledge of their income tax department. Beyond the knowledge. If somebody declared that, yes, I have money in Bangladesh in certain Sonali bank, it's okay then. You pay tax, you keep the money there. That's why now you see, for their own citizen, one law, but for the rest of the world is different. So they are the beneficiary of all money laundering. You see, now the amount of loan Western world is giving to Bangladesh, the amount of money laundering to their country from Bangladesh is much more higher.
No need, we don't need foreign assistance or law. If you can block this money laundering. Now, okay, there is then what you ask about how to bring money. Now you will have to prove that Mr. So and so has taken $1 million from Bangladesh, throw this bank to this bank, this bank to the. You will have to show the path, and deposited to American Express Bank in New York, and you have given this citizenship against this deposit. If you can give it the evidence, then only American government will seize the money and back to Bangladesh. So, those who have laundered the money from Bangladesh, you cannot prove it.
About a couple of years back, we came to know that a politician from Bangladesh bought about 30 apartments in London. And he was going about like it's no business, I mean, like normal day-to-day business. How could a man own 30 plus apartments in London? What is their law? Anybody can go there and start buying things.
I have explained some of the one story of American law. Similar law is in almost all Western countries.
Right.
But again, if you can prove this money has been taken away from Bangladesh, then they will intervene and send back the money.
I mean, like here, if somebody suddenly comes up, I go to a bank and I deposit suddenly, say, $20 million, and I start buying properties. At one stage, some authority from income tax department or government, intelligence agencies, they will start asking me questions.
Yes.
So whatever the UK, it doesn't happen. The Bangladeshi goes there and buys 30 apartments.
No. They have some legal coverage there.
Right.
They keep their one eye closed
Oh,
and look into the document. Where you got the money? Yeah, I paid the money. I paid the income tax. I got this money from there. My friends sent from Bangladesh or United States. These are the evidence. Somehow they keep their eye closed and approve it. But when you give your own evidence, this 30 house apartment bought by this Mr. So and so, and this is the way there is a record of hundi signed by this gentleman, and these are the witness. That's why what Bangladesh government is now doing, they are appointing the expert legal firm to track down the evidence and the procedure, how the money has been transferred from Bangladesh to other countries. So they are very expensive lawyers. To some extent, the legal economist also may be. This is also their profession. So what they do, they investigate. Something like investigating. They are also in the Western countries. Some lawyer also the private investigator as well. They have their own mechanism, own facilities, our own people to collect evidence. And that's why this legal procedure they follow on contractual basis. If I can recover $10 million, you will give me $3 million, something like that. So their fee is like on contractual basis. They will take a share of the recovered money.
Well, thank you, Mr. Siddique. Very enlightening and very interesting things that we didn't know. I didn't know. I'm sure our audience have enjoyed listening to you, and we will meet again. We hope to look forward to meeting you again and learn more things from you. And we want to thank you very much for finding time to come here and share your views and opinions with us. Thank you, viewers.
Thank you to the audience. Thanks to the organizer, and thanks to Shamin Wahid for inviting me here.
Thank you.